If you're creating content, posting reels, or building digital courses, you're sitting on a legal time bomb and you probably don't even know it, right? Every post, every download, every viral moment could become evidence used against you in court. And no, I don't sound like a bad cop. I'm Karam. I'm a 20-year attorney. I'm a business mentor for entrepreneurs. I've seen creators and entrepreneurs lose everything because they don't understand one simple truth. Just because you can download it doesn't mean you can use it. So today I'm going to break down the 5 biggest legal mistakes that content creators make. Mistakes that lead to copyright claims, licensing battles, and platform takedowns that you never want to be a part of. So by the end of the video, you're going to learn exactly how to build, post, and scale content the legally bulletproof way, and you're not going to learn it anywhere else. So let's jump right in. Mistake number 1 is using free content that isn't actually free, right? Nothing in life is free. Here's what most creators don't understand. Royalty-free does not mean license-free. Let me show you exactly what this looks like. You go to Unsplash, you download a free image, you use it in your course that you sell for $2,000, $5,000, whatever. 6 months later, you get a cease and desist letter demanding $50,000 in damages. I didn't send that one, but I've sent a bunch. But why? Because that photographer only gave you permission for personal use, not commercial use. And there's a huge distinction in the law between the two. Now, you violated their license agreement without even knowing that it existed, and that's no legal defense. So before you use any content, read the license, know what it means, and if you don't, ask a lawyer. Keep written proof of your commercial usage rights for every single asset. And when in doubt, the best case scenario, create your own content or pay for legitimate commercial licenses. Now, mistake number 2 destroys creators every single day. You hire a video editor, graphic designer, copywriter, what have you. They create amazing content for you. You pay them and you think you own it, but you don't. Because under copyright law, whoever creates the work, they're the author, they own the work, unless you have a specified legal document that transfers those rights to you. Now that means that your editor, your designer, your freelancer can legally take back their work and there's nothing you can do about it, right? They can license it to your competitors or even sue you for using your own content that they created. I've seen this scenario play out in court. I've defended it and I've actually prosecuted it. And it's pretty clear-cut law. Whoever created the creative work is the owner, unless there's a signed IP assignment of rights agreement, and a lot of times there really isn't. And that's a huge problem, right? So what you need to do is you have to make sure that you use a work-for-hire agreement, and one that's drafted by a battle-tested attorney, right? And you have to include an IP assignment clause in every contract or agreement. The magic phrase is, all work created shall be considered work for hire, and all intellectual property rights shall transfer immediately to your, whatever your company name is, right? No contract, no content ownership, period. Now, mistake number 3 is a big boo-boo. That's not registering your copyrights, and that's just amateur. You create a signature framework, a best-selling course, or viral content series that you work so hard for. It's making you money, you're building your brand, everything's perfect, and someone goes ahead and steals it, copies your entire system, and they start selling it as their own, and they're making money off your hard work. You want to sue them, right? You call a lawyer, and the lawyer asks, did you register your copyright? And you say, no. The lawyer then says, then you can't sue yet. So here's what most creators don't know. You can't sue for copyright infringement until you've registered your copyright with the US Copyright Office. And if you don't register within 90 days of publication, and publication is a legal term, you lose the right to statutory damages and attorney fees. And that's really important when you want leverage to not go to court. So that means instead of collecting 150 grand in damages, you might actually only get the actual profits they made, right? Which could be nothing. So what's the fix here? The fix here is to register your flagship digital assets early and often. It doesn't have to be everything, right? But your flagship, your signature course, your framework, your book, your template library, what you think your competitor wants, right? The cost of copyright registration is peanuts compared to the value. Now, mistake number 4 is not reading the platform terms of service. Now, every time you upload to Instagram, YouTube, TikTok, or LinkedIn, you're signing a legal contract whether you know it or not. Now, most creators never read the terms and conditions. No one does, but they agree to it, right? But here's the shocking truth. These platforms often get unlimited rights to use, distribute, and monetize your content Instagram's terms literally say they can use your content for advertising without paying you. YouTube can keep your content live even if you delete your account. They have a lot of power over your content. I've seen creators lose control of their own viral content because they didn't understand what rights they gave away when they hit that upload button. And like I said, most of you don't, and it's not your fault. So I know it sucks, but you really need to understand the terms and conditions of these platforms. You have to read them before you upload anything valuable. Consider keeping your best content on platforms you control then, right? Your website, your email list, your paid communities. I always encourage everyone to have a separate email list. You don't control those platforms. Now, mistake number 5 is repurposing without permission. And this is something I think most entrepreneurs all do. This is the mistake that destroys creators nearly every day, all day. You see a great podcast clip, a funny meme, a perfect background song, whatever it may be, and you think I'll just use 15 seconds, that's fair use. Everybody thinks they know what fair use is, right? Wrong. Fair use is not a get out of jail free card. It's a legal defense that you have to prove in court after you've been sued, after you've hired expensive lawyers, after you've been through the trauma, after you've spent tens of thousands of dollars. And listen, you don't want to be there. I used to go there every day. Nobody wants to be there. Even crediting the original creator doesn't protect you. Even using just a few seconds technically doesn't protect you. So if you're making money from content that includes someone else's copyrighted work, you're at risk, and you should really stop and think about that. So make sure that you use licensed content libraries like Epidemic Sound for music, stock footage for video clips, and create your own memes and graphics. If you're monetizing your content, every element really needs to be legally licensed for commercial use, or you have to create it originally. So those are the 5 biggest mistakes. Here's a couple legal concepts that you have to understand that goes with them. Like I said, fair use is important. It's determined by 4 legal factors: purpose, nature, amount used, and market impact. Courts decide this case by case. There's no magic number of seconds or words that's automatically safe. Commercial use makes fair use much harder to claim. So don't ever bet your business on a legal doctrine that requires a judge's interpretation, because that's going to cost a lot of money, and judges sometimes really don't know what they're doing. Now, there's derivative work liability, right? That's when you remix, translate, or build upon someone else's work. You're creating derivative work. Derivative work requires permission from the original copyright owner. Now, this includes translating courses, adapting frameworks, and creating variations on someone else's content. Understand that and be cognizant. Then there's DMCA and takedowns. When someone steals your content, file a DMCA takedown notice immediately. If you need one, I've got one. Just contact me. When you get a DMCA notice, respond quickly and professionally. False DMCA claims can result in perjury charges, and that's serious. Only file one when you actually own the copyright. So now you've learned the mistakes and some important legal concepts when it comes to bulletproofing your content. Now you need to really understand one of your biggest enemies when it comes to creating content, and that's the FTC. They're the regulators. They review your content for fraud, for deceptive advertising, and other issues. In fact, there's at least 10 things that the FTC hates about entrepreneurs and online businesses, and that's the next video that I'm recommending. The 10 things that the FTC hates about entrepreneurs. Click on the link below. I'm the battle-tested lawyer. Get Legally Bulletproof, and I'll see you there. I really hope that you enjoyed this video, but if you're sick of guessing whether your business is exposed to legal threats you can't see or didn't know was coming, those enemies, mistakes, and liability that cause entrepreneurs to lose, then I've got something very special for you. It's my free business risk report, the same kind of analysis I charge $7,500 for in person when I do my business defense legal mastermind. Click the link below. Answer some strategic questions about your business and get a personalized risk report. You've got nothing to lose. Find out what's hunting you and your business before it destroys everything you've built. I'm Karam, the battle-tested lawyer. Stay legally bulletproof, please.